Hello guys, good evening. So everybody listen to me, no problem. So I cordially ask you to open your video. So I want this lecture to be yeah, so communication on each other. So today is as far as I know the last session of this class in this semester. So yeah, it's kind of unbelievable that so we just met. It feels like just 2 or 3 weeks ago. So on the first week of March, but so we are already at the end of this semester. So so it has been announced. Today's lecture will be how to say AI decision making. So inside the administration and how we can kind of understand the kind of decision making process and how we can build up the reviewing system of the kind of AI or data-based agents decision making. So so the reading materials has been already shared, but I will share again. So I'm sorry that it's still written in Korean. So, but it means the agent's decision making. So in the age of AI and judicial review. So it is composed of 4 or 5 sections, including the conclusions. So I expect that you have been already tried to read and understand these topics. So I will briefly overview these contents and go into Q&A and discussion sessions. So the section 1 is the technical understanding of AI. So I'm just a lawyer, but so I guess that you are much more expert in this topic than me. So it's somewhat maybe looks funny that I do this kind of lecturing. So but so we can see that the conceptual framework of AI from deep learning to representation learning and machine learning and the AI which include all this kind of decision making through data or computing system. So we know that also the AI or artificial intelligence has been developed from mid 20th century until today. So from kind of basic algorithm way of artificial intelligence to machine learning and deep learning. And this is the simple illustration of deep learning, how the AI system is capturing so small minimum data to getting more higher layers of data and featuring, so through which how the output has been drawn. So this is another diagram. So at the right far sections, we can see the deep learning. So from input and from it, simple features are found out. So on which additional layers of more abstract features and on which mapping from the features and this will be leading to the output. And so I understand there are some technological discussions about AGI, so artificial general intelligence or general artificial intelligence. So as far as I know, so the AI techniques nowadays so working on maybe the healthcare applications you are studying this semester are not cannot be defined as AGI because basically that AI is still task oriented, but the AGI is the intelligence of a machine that could successfully perform so any intellectual task that a human being can perform. So this is kind of quite different level of AI. So by learning from my colleague at in this part, so as far as he knows, this kind of AGI is not feasible up until now, so, but also in the near future. But once this kind of AGI, the GAI, is developed, so this will be a whole new world and whole new paradigm in artificial intelligence. And section 2 is about the legal understanding of AI. So I know something about this topic and maybe some more than you. So I can say that the legal reasoning is composed of these subsections and sub-concepts from fact finding and applied rules and judicial reasoning and legal outputs. So so we are living in, how to say, in the daily lives, and many things happen around us, and many uh, factors are, how to say, are happening and gathered, and something happens all around us in daily lives. So among the many things happening around us, some fact or some event are beginning to have legal meanings, and that kind of uh, legally based fact are uh, applied to legal reasonings, then some legal effect provided through that kind of daily lives. For example, so you meet your friend and talk daily on small talk about weather or something like that. So among the dialogue, so your friend might be somewhat asking, kind of lending to him some money. So so you will think about that issues, and when you agree, and of course that the contract can be made only by oral agreement, but generally we as writing letter of agreement when the kind of contract to be made effective. So once the kind of signing for the letter, so this is beginning to have legal implications, and then it will bring about legal effect. So through which you may have some right to ask um, paying the money, and on the other friends are under the obligation to pay the money until some deadline. So this kind of legal effects are provided through the kind of daily life event. So this is and this is the basic framework of legal reasoning. So as I mentioned, so it begins from fact finding, and uh, in that founded fact, rules and regulations are applied, and through which judicial reasoning is happening, and through which legal output or normative judgment is provided as output. So this process of legal reasoning seems like, or sound like, quite similar to this kind of deep learning system. So based upon inputting so many facts through which on which many featuring or applying the kind of featuring applications are happening, and through which uh, the output is provided. So I feel that this kind of process in machine learning or deep learning and legal reasoning are quite similar each other. And so to be more concrete, this kind of the way this legal reasoning is done is somewhat different from civil law system versus the case law system. So on this topic, I remember I gave some lectures in the previous lectures. So so we can think about artificial intelligence in legal reasoning, so versus of deep learning in legal reasoning issues. Well, so this is somewhat in detail topics about agency decision making and artificial intelligence. So in legal terms, it is quite essential to divide so-called, how to say, in Korean, it's 법규상 versus 비법규상. So 법규상 means some issues which can uh, which can affect on your right or duty. So on the other hand, the 비법규상 means some issues which will not be affecting your right or duty. So in this sense, the focus in agency law or agency this decision making process is more on the right or duty issues. So 법규상. And these issues of right or duty should follow so-called rule of law principles. And for the agencies to do some decision making, which will have effect on your right or duty, so that agency should be delegated that authority from the Congress via legislation process. So this is called delegation doctrine or non-delegation doctrine. And through this kind of delegation process, that agency decision makings are made in many fields, in every aspect of our lives, from police administration to welfare state administration, or sometimes in the risk administration topics. So in all this kind of agency making process, so we can follow the same process of fact finding and the interpretation of legislation. So and the scope of discretion of agencies and the judicial review of the judge or on that agency decision making. So this was the orthodox or traditional way of explaining the agency decision making in administrative law. But but in the near future, so we will be living in the world where the artificial intelligence is in any way working in this administrative decision making. So so deep learning is working in this kind of process. So in that new world, so there will be new legal issues which was not happening in the past when the agencies as a human being were just making decisions based upon many document or many fact finding or whatever hearing process or something like that. So the first topic will be the accountability. So when the kind of artificial intelligence based agency decision making is, how to say, sometimes it can be a discriminational or maybe biased with some error, so through which some bad output may be provided. So when the kind of failure happens, so how the accountability issues should be solved. So whether that accountability can be given to the algorithm developer or as we talked, the kind of accountability can be directly given to algorithm or AI itself. So in general, so we frequently talk about this accountability when the AI system provides wrong answers. But as I mentioned, maybe at the last class, so maybe sometimes we can think about the outcome could be too much reflecting the reality of um, so our inner mind. So basically, you are quite good persons, but not all of human beings in this world are the kind of purely good human beings. So some human beings are having very bad temper or temptation to discriminate or temptation to do some harm to some other people. But this is composing all the data um, around us. So maybe the deep learning or machine learning will be based upon the kind of general data, so in which the kind of bias or harmful intention can be also included, and this will be featured in the layered scheme, and through which maybe some bad outcome will brought about. But this might be so reflecting too much truth in ourselves. So in this case, so how the kind of accountability issues should be addressed on. So this can be another quite interesting but quite serious topic. So the next topic might be transparency or explainability issues. So when the AI system is working as a black box, so inside which nobody can know what is happening, or through what kind of node connections that final decision making has been made. So that how we can guarantee the transparency or traceability or explainability issues in is quite serious. So this is basically important topic in just general AI system, but this can be more important when the AI decision making is inside the government or inside um, agencies, because the basic feature of government or agency is that they can do some power, coercive power, sometimes um, without the agreement of the people. So the kind of coercive power is justified under the um, national level or administration. So this can be quite a serious topic. So so how much transparency or how much explainability is quite important. And finally, what should be explained and what can be explained. I'll skip this part. So I'll move on to the judicial review topics. So as I briefly mentioned, the nature of agency decision making is, I can say that it's balancing between the delegation versus efficiency. Um, so delegation means, uh, especially like in a democratic society, so where we are living, um, so the traditional, how to say, the direct democracy is not possible because uh, we are living, such a big society, so composed of too many people, so that all of them cannot gather, so like the Athens in the Greek period. So we should just go follow indirect democracy. So through which the delegation happens. So for example, the elections or majority rules or party system, so or national assembly system. So this is all about delegating process through which the authority as a people, some part of your right or your authority is delegated to the agencies. So, so this delegation is finally given from Congress or National Assembly to the administrative branch or agencies. So through legislation, so so-called through the principle of rule of law or delegation or non-delegation theory. So this is the one aspect of modern administrative state. So but also for this delegation principle to be fulfilled perfectly, so maybe we can request that all final agency decision making should be delegated from the people. But this will bring about quite inefficient cost because it will take too much long time or too much long process or something like that. So, but with that, to high the delegation requirement, the efficiency cannot be retained. So to get the efficiency, so we are allowing some discretion or discretive measures for the agencies. So with that, the public officials or agencies can do can exert or some discretion on their daily decision making. So this is getting more important in the how to say modern risk management or risk administration because this is based basically under the uncertainty restrictions. So this cannot be fully delegated by the people or by the National Assembly from the first stage. So they should be allowed to some discretion. For example, to getting actions against COVID-19 situation or in the pandemic situations or the kind of issues, the discretion of the agency is inevitable. So in this framework, so the balancing between the attaining the delegation versus maintaining the efficiency is quite crucial. And this is the most important topic in administrative decision making issues. Uh, and and we can guess in the near future. So as you have been already researched, many AI system has been already how to say provided in the private field, in the medical field. So, but in the near future, so this kind of AI system or database decision making will be taken by the inside the government or by the agency decision making process also. So in this case, we can name it as administration by data or administration by AI. So this will be the world where we will be living in a very near future. So I remember there was some movie. The title was Minority Report, in which the Tom Cruise. I remember Tom Cruise was the actor. So that was the story about in the future. That movie was very long time ago. I don't know when exactly that year was, but maybe the movie was describing the future. I'm not sure that was more future than 2021 or whatever. So it's a story about the some systems which can predict which person will do crimes or not. So that they can decide. And with that decision making, some squad can just go out there and kept arrest him. And so even before his crime happens. So this kind of preventive measures could be maybe imagined in this kind of AI-based administration or in the general artificial intelligence system. So this might be the new challenge we are facing upon in agency decision making in the AI. So other topics are quite interesting, but include quite huge topics. So I will skip that part. So before going more in detail, so I will explain explain two principles, which the one is the proportionality principles, so which is basically applied to civil law tradition legal system, so versus so-called the Chevron doctrine or Chevron difference principles in the United States, so which is based in case law state. So the proportionality principle is the basic and frequently used principle in doing the judicial review of agency decision making. So so nowadays in the modern state, many national decisions are made by the agencies. So, but not all of them are right answers or adequate or efficient. Maybe so. Even some discretions are given to agencies, but their final decision might be reviewed as illegal, which should be corrected by the judges in the court. So in deciding that whether some agency's decision was correct or not, so this proportionality principle is very commonly applied. So this is composed of these three sub principles. So for the agency's decision making to be legal, these three requirements should be fulfilled. So first, the aim of that agency's action should be justifiable, and secondly, the means to achieve that goal should be appropriate, and thirdly, it's kind of narrow proportionality. So even the goal is justifiable and the means are appropriate, the relationship between that goals and means should be proportional. So this is somewhat abstract, but maybe so when doing some disciplinary measures against public office officials, for example, the chief prosecutor. So when some committee decide that, for example, three months stay of his position for some reasons, so that committee's decision should be reviewed by the court following these three principles. So the goal or the aim of that disciplinary measures is justifiable, and the means, for example, 2 or 3 months stay of his position, is it appropriate or not? And thirdly, so whether that kind of 2 months or 3 months is narrowly, in a narrow sense, is proportionate or not. So in this process, that agency's decision making is reviewed by the court. Maybe now you are quite familiar with these topics. So, so on the other hand, in this Chevron difference principles in the case law system, I should say that in this proportionality principle, is based upon the assumption that at the final stage, the judge himself or herself can find out the right answer for that issue. So, what kind of measures was the right measures for the agency should have taken? So through this kind of leveling up, so it is assumed that the judges can reach and find out and reach to the exact or correct answers to that issues. So this is the basic assumption. So on the other hand, so under this Chevron difference principle, this principle is not following the kind of assumption. So they accept that judges cannot know every issues and every topics, and judges cannot find. However, they try best. They cannot reach to the right answer to that topics. And so with that, so Chevron difference principle is composed of step 1 and step 2. The first step 1 is to looking into the legislation which passed the Congress by the majority rule, and by looking into the wordings of the legislation, they try to find out the intent of the congressman is obvious or obscure. And when it is found out that it is obvious, that then it's simple. So the judges can just follow, and the agency should follow that obvious intention of the people in the National Assembly. So because that is the right answer of the delegation from the people. But the thing is when the intention of the people or the legislator is not obvious. I mean, it's obscure. So then the judges go to step two. In the step two, what the judges is doing is not trying to find out the right answer of the case. Rather, the judges just try to find out so whether the agency's decision making was reasonable and permissible. So when that was reasonable and permissible, that agency's decisions are maintained in the court level also. So the only case when the judges change the agency decision making is that when he or she finds out that the agency decision was unreasonable or impermissible. So this is somewhat or quite different from this proportionality principle, so which is based upon the assumption that the judges can find out the right or correct answers to that issues, but the Chevron deference rule is not following that assumption. So what the judges just do in the step two is just to looking into that agency's decision was reasonable or permissible. So when it is found out that it is reasonable and permissible, even if the final answer to that case, what the judges think correct is different than what the agencies really did. So that agency's decision are still maintained. So this is quite different topics.
Professor, Yunbin has a question.
Oh, okay. Where are you, Yunbin?
Here.
Okay, no problem. So what's your
I would like to ask, what is the meaning or definition of reasonable or permissible in juristical meaning?
yes, yes, that's a wonderful question. So this is the basic explanation of Chevron deference rule, and the step one and step two. And step two is saying that whether the agency's decision was reasonable or permissible. So of course, it's not easy or simple questions. As I mentioned in the case law system, so the meaning or the definition of the reasonableness is collected and how to say interpreted through uh, huge collections of cases. So in which each judges find out that some agency decisions were reasonable or not, and another judges do that kind of thing again. So through which many precedents are accumulated, and through which the meaning of reasonableness is maybe defined or found out by case law system. So this is the simple answer I can give you at this stage. How about that? Is it good?
Yes, and so the permissibility is also the same with reasonability.
Yeah, yeah. The basic outline is the same, reasonable and permissible. So it's defined and accumulated through many cases collections or case accumulation. So of course, I can do some more explanations in what kind of cases that reasonableness has been interpreted as such or something like that. But I guess this should be, get all of you too much in legal class. So maybe if I have another chance with another questions, maybe I'll try some more. Okay, thank you.
Thank you.
Okay, so anybody else having questions? Do you see anybody, John Chang? No, then I'll move forward more, so which will not be much longer. So, for example, so there was some how to say on kind of how to say disciplinary measures through AI, how it can be reviewed by the judge or by the court, so which can be quite important topic. So this is the topic of section 4, so which means the agency decision making in the AI and judicial review. And we first should think about so how much and in what way so AI can substitute the traditional agency decision making. So does it can do only the process wise, or it can kind of substitute the output itself or something like that. And I'm not sure how many of you and how often you have been exposed to agencies, but I can say that um, the most important topic in the public officials in mind they have is how to guarantee their defense for their decision making when something went wrong. For example, when the how to say the political power has changed or something like that. So when some kind of investigation begins for that agency decision making, for example, in Korea, how to say denuclearization has been quite how to say quite serious topic. So and there were many agencies dealing with that kind of topics, but you know that kind of agency decision making can be in any time when the power of politics has changed. So this can be quite serious issues, and maybe sometimes investigation has been already begun. So in this kind of situations, the public officers place at their foremost importance how to they can guarantee or yeah maintain their defense legions. So this was the traditional story, but when we go into the world of agency decision making through AI and data, then we can guess that this AI system or data will be their major defense for their final decision. So they will say, oh, so I didn't know much about these issues. So there was just some AI programs our agency is using, and through which this output has been provided. Then, okay, so then there will be quite interesting legal topics. So, and when this happens, how the judges can review the agency's decision making. So the kind of proportionality principle or Chevron difference principle will be still in effect, but the contents can be quite different in the AI system. So from the selecting of data set or the working of labeling, and the developing algorithm and doing interpretation level. So in each stage, there will be quite different issues will be raised. Then there are some discussions or like kind of level of trial. So for example, so in traditional trials, so we are quite familiar with three times of trial, like district court or high court and Supreme Court. We are quite familiar with that kind of system, and we expect that by doing that kind of leveling, the biases and the failures of judges' decision can be corrected to more optimum output. So there are some issues whether we can develop that kind of leveling system of AI. For example, the first level AI decision. So when it's not good, so they can give partition to move up to second level of artificial intelligence, and finally at the supreme level of artificial intelligence. So this might be possible in conceptual level, but what I found from professors in that part was saying that it's not technically possible, because once in whatever level AI system means the same level of technological how to say exactness or technological completeness. So he was saying that it's not imaginable that the leveling of artificial intelligence can be systemically developed and do working successfully. And maybe sometimes it's quite often how much the jobs of lawyers or the jobs of judges can be substituted by judges. So in sometimes this kind of judicial review itself can be done by AI system in the court. So how much it can be successful or not. So this can be another interesting topics. So this was the summary of the AI-based decision making in the agencies, and this was quite abstract level, or sometimes estimating or imagining what kind of things will happen in the near future, the AI-based system. But so this is how to say in United States level. So how much the real agencies or administrative decision makings are done or based upon the real data or AI. So for example, so the FEC's campaign finance data or the EPA's toxic release data and the CFPB's consumer complaint data and CPSC's product safety data and Medicare's quality data or FDA's adverse event data. So these kind of data are all accumulated already in a huge volume, so inside the government or inside the agencies. So, and we can easily guess that many new agency decisions are based upon this data set. So I can say this is just not future. This is already the present we are living in. So, and this is from the paper in 2018. So this paper says that how to say 196,000 searchable database is provided online in agency decision making. So in this sense, we are living in the world of regulation by data, and so in this sense, how to guarantee or protect the transparency in market and regulation and democracy from the perspective of AI or data is quite critical issues in modern legal jurisprudence. And there are some suggestions that the government role is kind of a data steward, because in this kind of machine learning or in the deep learning sphere, the government or the agencies cannot do, how to say, review what is happening in the process. So they, rather than that, so their proper role is properly stewarding the collections or analyzing of the data and providing some measures based upon the data. So this is quite abstract level of suggestions. So we don't know how it will happen in the real future. So in this sense, that the traditional legal principle, for example, non-delegation, how it can be changed, like the cyber delegation or statutory sub-delegation. So, or the traditional due process principle can be changed to evaluation of adjudicatory algorithm or cross-examination of adjudicatory algorithm. And how we can deal with the anti-discrimination issues and transparency. And for example, suspect classification or inferring discriminatory intent. And in transparency aspect, how to get the religion giving and how much disclosure duty should be levied upon the agencies, or these kind of new, quite traditional topics, but there will be quite new phase in dealing with this kind of issues. So, and in this respect, how much the normative decision making can be given by the AI. So, in a legal field, the division between positive world versus normative world is quite essential. So the positive is what is happening in the real world, or something like that, or empirical or positive issues. On the other hand, the normative world is how this world should be, how to say, should be managed, or how people should do, what kind of moral or ethical obligations so people are given, or this kind of things. Maybe in deep learning or machine learning techniques, so we can guarantee much higher exactness or efficiency in this positive way, positive sphere. But the question is how much the AI can do their workings in the normative decision making, or how much human beings can follow the normative orderings of AI, or would that kind of thing will be good or beneficial to human beings or not. So this can be quite interesting topic. So in this aspect, the relationship between AI and ethics, and AI and discrimination, and furthermore, the AI and democracy can be a quite interesting topic. So this is the topics I prepared under this big title. So it's quite legal dialogue, but I hope this was kind of somewhat interesting and helpful for your study. So is there anybody who has questions? So no, so let me just briefly explaining the negligence rule in the automatic driving system. So I remember we talked about these issues before. So this is about how to design the liability systems in the automated driving world. Maybe. So this is the basic purpose of tort law or damage law. So firstly, it is doing the compensation law. So protecting or compensating the victims from the illegal actions of the, harmful activity. So this is one purpose. In addition to that, in our this kind of modern world, which is quite complex and dynamic world, so the functioning of the deterrence is also the one purpose or goal of tort law. And in addition to that, the tort law is doing risk management through insurance system or something like that. So this is what tort law or damage law is doing in this modern world. And so in the automated driving system, in designing new negligence rule, so this kind of purpose should be considered. And as I mentioned, so we can think about three different kinds of negligence rule. For example, strict liability rule, or no liability rule, or negligence rule. So according to the field and aspect of the activity, so we can efficiently or optimize this legal system by choosing from these different alternatives options. So I'll skip this part. And so we should also think about the technical understanding of automated driving. And so we can also think about the legal understanding of automated driving, and also the players surrounding that automated driving. Firstly, the developer of algorithm, or if it is done by machine learning, then the information feeder will be doing quite critical role. And in still level 3 level of automated driving, still the driver himself or herself is still doing some functioning. And the car makers are doing some role, like Elon Musk will be surely doing something, or network operator will be also doing some role, and an insurance company will take some part. So according to what kind of negligence rule is taken in the future in the ultimate driving system, so how much liability and will be given to each players, or in what way, and according to the kind of decision, the future of technological development surrounding automated driving will be quite different. So as I mentioned, so in a technological aspect, so we are already in a quite higher level, but the reason why we are not living in the real automated driving world is because the legal system has not been fully agreed upon or developed. So this will be another quite critical issue. And in this sense, we should think about so-called negligence, or kind of the caution level in the automated driving system. So we should redefine this concept. Maybe we can get some reference from liability, product liability, or non or kind of risk liability issues. And so it is already quite much working, but the insurance system will be doing much higher level of functioning in the future, I guess. And the goal of automated driving liability system or negligence system is based upon this assumption that it should achieve these three different targets. So first is the fast compensation for the victims of the driving, and that's one thing. And secondly, the efficient operation of car insurance system. And thirdly, so it should give some incentive mechanism for automated driving technology. So this can be the small the targets of in designing this system. So according to NHTSA categorization, so this automated driving is divided from level 0 to level 5. And as of now, so level 3 automated driving is so under this level 3, so that discussion is going on. So which means in certain conditions, the driver can delegate the operating to automated driving system, but the driver should be always prepared to get back that operations when something happens. So when he or she does not do properly, he or she can be under legal liability. So, and in Korea, so there has been some suggestions about how to design that library system. So the first one was just applying the current regulation as well. I'm not sure this can work properly. So the second proposal was to for the car maker to take no strict liability system. So once accident happens through automated driving, then the car maker should compensate the damages. But after that, some insurance mechanism will be working in what way. And the third one is the co-strict negligence rule, so between the driver and car maker and insurance system. But there has been some legislation in the last year, but it's not to the concrete right or duty level. It's more abstract level. So according to technological development and social consensus on how to efficiently divide the liability between the players will be key issues in the future. So this was another separate topics. So including the first topic and the second topics, you can freely give your opinion or your questions. Okay, so Soyeon Kim.
Yes, thank you for your lecture. It was really interesting and it really was helpful for me. Actually, I have like 3 questions, 2 from the class and 1 for the report. And the first one is about the Chevron deference, the paper you wrote about. It seemed that Chevron deference was really important for judiciary because it was like saying that, hey, we judiciary people need to respect some expertise and professionalism of the agency, so that we should respect the decision making of administrative agency. And even though those AI system is not AGI level, it's still artificial narrow intelligence. Still, it has really, sometimes surprising capacity. So when the administrative agency make some decisions with the help of those AI systems, then I think it will strengthen their expertise and their professionalism. And it seems like that Chevron deference will be even more favored in the future. So I was wondering what would your opinions about the trend would be? And second question is about the liability issue, because for low level of the AI system, the liability system that we still have can cope with the problems from when we use those systems. However, when we use level 3 or level 4 and level 5, liability discussions will be somewhat different for each level, I guess. And as far as I know, the government is trying to allow companies to sell those level 3 self-driving car. And I heard that the liability discussion in terms of dealing with the problems due to those level 3 are the most difficult one, because it has to consider the interaction between the machine and human, and it's most complicated in this level 3. And I want to know if there is any organized form of the discussion in terms of the liability issues in level 3. And after I hear the list answers for these two questions, I want to ask you about the question for the report.
Yes, yeah, wonderful questions. Yes, I'll try my best to answer properly. So I'm very much anticipating your third question also. So as far as I know, so in the traditional world, in which the AI or data was not factor in agency decision making, so I was thinking that what kind of principle the judiciary should apply and in doing agency decision making review. As I mentioned, so Korea is basically following the civil law system, and in the sense that the proportionality principle is quite familiar to Korean judges, and they are actually doing using that tool, like how to say 전가의 보도. I'm not sure how it can be translated. Kind of, it's quite strong and good sword judges can use in deciding that kind of issues. As I mentioned, it is composed of three small principles, and many judicial decisions are written in that logistics. So in a shaping, in a superficial shaping, it seems that through that kind of logics, the judges can find out and reach the right answer for that decision. For example, whether to stop nuclear generator or not. So whether to do four major levers development for like under Lee Myung-bak government, the developing of four big streams of lever was quite political debated issues. So whether to stop that development or allow that development. So that role was given to judges actually. And again, so whether to kind of in this government, so many the kind of not easy issues has been raised, and somehow that was done in the agencies, and the reviewing was done in the trial. But I should say, I should confess, so even I was a judge, I'm not sure. So yeah, as I mentioned, even I was a judge like Hercules, and we studied in the jurisprudence, so I could find out the right answers in every topics or in every cases. But I'm not the kind of perfect kind of super judge or like Hercules. I'm just a human being like you, with many weak point or that kind of thing. So it is too much that I say that, okay, give all the document and then I will look into, then I will find out the right answer and compare that my right answers and the agent's real decision making. So when it is not the same, so I will cancel the agent's decision making. So this is still the abstract explanation of the proportionality principle. So I should say that it's not fully real. It's quite, how to say, meta real. It's kind of assuming that judges can do that kind of thing, but it's not completely real. So in that sense, the Chevron deference rule is much more, how to say, pragmatic or trying to optimize that decision-making role. So at the step one, the judges are the professionals in interpreting the wordings of legislation, so through which they can do their best to find out the intentions of legislators. So once it is found that obvious, so they can just order that exact intention has been executed or not. But the basic aspect of languages is, yeah, it always kind of is with the obscureness always. So then that obscureness might be sometimes unintentional by the National Assembly, but in many cases that obscureness is quite intentional in the politics area, because the more exact or the more obvious some legislation wording, as much the dissenting or opposing party will be try their best for that legislation not to pass the Congress. So it's kind of quite intentional obscureness is the one aspect of statute-less interpretations. So after that, so the Chevron deference rule is saying that the judges can do whether that was reasonable or permissible. So the basic assumption of that the principle. And I remember that your question was that under AI or database decision making, so which principle can be, how to say, do better or like something like that. So in this stream of understanding, so I should that the probability of that proportionality principle working in the AI will be much smaller, because with the kind of technological issues and AI issues, maybe judges cannot find out the right answers in the final stage, because it's quite difficult. But in the Chevron principle, so it is giving quite another challenges, but we should try to develop new difference rule. So how much explainability or transparency has been guaranteed in the AI system, according to that requirement, that the level of difference will be decided separately. So, but I should say, so we should do trials to optimize the level of difference according to that demanding to AI system. So I should say that was my answer to first questions. And I remember, what was your second question? It's about automated driving system, right? Yeah.
Right.
Yeah. So how much the legal discussions or regulation has been provided in about the automated driving, right?
Yes, and as far as I know, level 3 autonomous driving car has been started to be sold to the customers already, especially the Japan. And if consumers are buying those products, it means that some legal discussions are quite completed in certain point at least. And I heard that legal discussions for level 3 cars and legal discussions for level 4 and level 5 is a completely different one, especially the liability issues.
Right.
And actually, I'm studying the level 3 car, autonomous driving car. So I was wondering if there were any completed or organized discussions about this car.
Yeah, so good question. So I should say, so as of now, so not complete new regime of negligence rule has not been provided. So even level 3 automated driving. So I can say that it's the combination of product liability for the car company and the driving liability rule, because in the level 3 it's still involving the human decision making at the final stage. So in that sense, the traditional human liability based negligence rule is still applied to the driver. So I can say that's the status of known in Korea as of now for the level 3. But I can say that it's not on efficient regimes. So we need to develop how to design new liability system according to which maybe the future of level 4 or level 5 will be following that negligence system. Okay, thank you for the good question. So can I ask your third question?
Yeah, actually, our team is studying the the system named WebSEP. It's like within the system, the artificial intelligence suggests the dentist about how they do the cephalotracing autonomously instead of human, and I thought that it is registered as the medical device in Korean medical law. But then I found out that I couldn't search this name. I went to the site of Hospital Insurance Review Agency, because as far as I know, if any device is to be registered officially as medical device under Korean medical law, it should went through some trials and all the due processes. But then I couldn't find its name, and I found that that's because it's orthodontic device that the insurance doesn't cover. And then actually last time, Professor Zikari asked us that whether this device is registered as medical device in Korea and whether these went through some trials. But then we couldn't find any evidence. And I was quite confused that if this kind of device is not registered, while this device is not registered as a medical device in Korea, still it can be used in dentists or orthodontists in Korea.
Okay, it seems some lagging. Okay, so I cannot say that I fully understood your questions, but as far as I understand, so your issues and questions are kind of the kind of new system, WebSEP or something, some also identical medical device, which is assumed to be based upon AI. So the first one is whether it can be or it is registered as medical device, according to which the dentist or doctors can use that device or not will be decided. And the second level will be so that can be covered by the medical insurance system in Korean, medical insurance system or not, according to which the money the patient pays to the doctor will be quite different. So I didn't fully capture the questions, but so we need to think about the medical law or according to agencies' rulings, how some medical devices can be registered or not, according to which doctors can use the device or not. And the second level will be, so that kind of using of medical device can be covered by insurance system or not. So my guess is that the Korean system is not it's not going that much, but yeah, so I should say that we need to look into more and get some more information to answer correctly. So, okay. So somehow Sohyun Kim has vanished, but I hope this was answer to her questions. And so I can see that it's already 90 minutes from the beginning of this class. So Sohyun, are you listening me?
Yes, I had some internet problem here, so I just get back again.
Yeah, but so not fully enough, but I tried my best to answer your questions even without you. So maybe you can check at the video later. So I ask um, J1 to kindly do that. So
Thank you.
again, so even though so today's talk was quite legal and quite how to say comprehensively difficult topics, but I'm very much appreciating your attentions all through the times, and uh, I can guarantee that. So I tried my best to prepare topics which can help you. So you are the best expert in AI system or technology issues or medical issues. But as we all share, so all that kind of issues is closely related to privacy issues and law and regulation governing that topics. And to understand that frame or to find out some ways to find out answers. There was some basic legal understanding and jurisprudence or something like that. So that's why I prepared topics for the 5 lectures. And again, I hope that my lectures and discussions with you will helpful, not just in this semester, but also you're studying in the future. So I should thank you very much for all of you, and yeah, wish you good evening.